I'm Nikki Jovicic from LookUpStrata and also the Managing Director of Tower Body Corporate, a body corporate management company servicing Queensland. Today we welcome Chris Irons from Strata Solve. Chris is speaking with us about administrator appointments in body corporate. If your strata scheme doesn't have a committee or bills aren't being paid and problems are mounting, today's webinar is essential viewing. Plenty of people think their strata scheme is dysfunctional and might benefit from having someone come in and restore order. Is that really the answer, or is there a better way forward? And if you do need to have an administrator appointed, what does it involve? We'd like to remind everyone that this is a Queensland session and any reference to legislation is specific to the state of Queensland. Before we begin, I'd like to mention that the information in this session, including the discussions that arise from submitted questions and chat conversations, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in the session. We're delighted to be joined again by Chris Irons from Strata Solve. With an unparalleled perspective on strata issues, Chris Irons is a thought leader for the strata sector. For over 5 years, Chris was Queensland's Commissioner for Body Corporate and Community Management, and this is the only role of this type in the world. Now, as Director of Strata Solve, Chris is an independent strata consultant helping clients to untangle their strata issues with tailored practical solutions. In November 2022, Chris was elected President of Strata Community Association Queensland, and SCA works closely with government, members of parliament and other stakeholder groups to further the interest of its members. Chris brings to the table over 2 decades of public sector leadership and policy development, and he's a nationally accredited mediator and a strong advocate for trying to resolve strata disputes without the need for legal proceedings. Welcome, Chris. It's always a pleasure to have you on board and joining us today.
Thank you so much, Nikki, from an oddly kind of chilly Brisbane. Just chatting about weather beforehand. Crazy temperatures for those people in southeast Queensland this week. A much nicer day today, still nice though. And for a topic which you wouldn't necessarily call nice, but nonetheless, it's an important one to go through. And I just want to reiterate what Nikki said. I'm not here to provide legal advice today. There are many, many, many great strata lawyers out there that can assist with specific legal advice. Today, it's about general information, but significantly practical strategic advice to you on a pretty challenging subject, I think. So with that, I'll do the thing where I attempt to share screen. When we talk about dysfunction in strata, for those people who've ever seen me present things, I always find a way to include The Simpsons somehow in the discussion. And I think this this graphic is very much what I think people would be thinking about when they think about dysfunction in strata. Constant dispute, constant conflict, and then perhaps the utopia which may result if things get better. Of course, in this particular GIF, you'll notice that things do not get better. It's merely that somebody, Kent Brockman, happens to be looking in at that particular time, which kind of is a nice segue into what we're talking about when you think about it. So today, then, what are we actually going to talk about? The phrase dysfunction is bandied about an awful lot in strata in Queensland in particular, and I dare say elsewhere across the country. I just want to talk a bit about what that actually means. Is it as straightforward as we think? I actually don't think that it is, and you'll find out why in a moment. While I don't usually like to go negative in this case, I think it's important to also spend a bit of time talking about what dysfunction is not. I have literally lost count of the number of times somebody has come to me and said, Chris, our body corporate is dysfunctional. It's terrible, it's this, it's that. And when you dig down, you find out that's not the case. So I'm going to go into that in a bit more detail. And I think that's really important, regardless of whether you're watching. And as Nikki said at the start, administrator appointments, I'm talking here from a specific Queensland perspective, but the issues here are germane across the country, I would suggest. Then I'm going to talk about administrator appointments. I understand there are administrators in other states and territory. The process for having them appointed does differ. So I'm going to talk about the process in Queensland. Importantly, then, I'm going to put to everybody the idea that there are alternatives here, and alternatives in pretty much every case. Maybe not every single one, but most cases, I would suggest there are alternatives. As usual, I always finish with my top 5 best practice tips. And then I'm hopeful that we'll have a bit of time for some Q&A at the end as well. All right. Dysfunction. So I'm a word nerd. Words are everything to me. And when faced with any kind of discussion or issue or back and forth, I always have a look at the words on the paper. So here, what does dysfunction mean? So that, I think, if memory serves me, I took that extract from the Oxford Dictionary. Abnormality or disturbance of function. So you look at that definition and you go, okay, so what that's saying to us is that we have a normality and now we have something which is not that normality. Or we have some functions, some actions, and the process of those actually being carried out has been, as the phrase says there, disturbed. So that's okay, that's that. Let's drill down a little further then. I'm always big on the origins, on word origins. So dysfunction in this case, from the Greek dys, meaning bad or abnormal, and Latin functio, to perform, and ion, indicating action, process, or state. So, okay, so what we're getting to there is, okay, we're talking here about something which deviates from the performance of actions and processes. We're starting to get somewhere with this idea of dysfunction. Let's go into that a little bit further. So what I'm going to present to you now is extracts from 2 different adjudicators' orders in Queensland, which talk about this idea of dysfunction. For a little bit of context for everybody watching, in Queensland, we have such a thing as the Office of the Commissioner for Body Corporate and Community Management. You can think of it as a statutory authority in some respects. I used to be the Commissioner, and that office has the exclusive jurisdiction to resolve pretty much every strata dispute in the state. One of the ways in which they do that is via adjudication. So adjudicators are a bit like magistrates. They make legally binding and legally appealable orders. So it's an adjudicator in Queensland who appoints an administrator and determines if one is required. So here's some extracts from 2 different adjudicators' orders on the topic. Here's the first one, discussing this idea of dysfunction. And we'll go through this. Typically, there will need to be evidence that the body corporate or owners corporation or strata, depending upon where you are, is so dysfunctional, there's that word again, that it cannot operate properly within the statutory framework, okay? Or that there is financial malpractice or undue oppression in the conduct of the body corporate. So there's a few component parts there. Financial malpractice are very specific part. I think everybody has a pretty good understanding of what financial malpractice is. First one relates to the definition that I just had up on screen. And then the last one's an interesting one, oppression in the conduct of the body corporate. So here you can see that those concepts about operation, conduct, carrying out responsibilities within the statutory framework. In Queensland, the statutory framework is set up in such a way that it is expected the owners will manage things for themselves with the assistance of people like strata managers, management rights holders, lawyers, consultants, whatever. But largely, decision-making is all on the owners. That's the concept in Queensland. I dare say that concept's repeated elsewhere as well. If you want to look at that one in a bit more detail, that reference there at the bottom of the page is the case reference. So you can read that one in a bit more detail if you wish. Let's look at the second one then. And this is a different adjudicator coming at this question from a different perspective. But again, this is all about this idea of dysfunction and whether an administrator is warranted. The type of dysfunction that warrants the appointment of an adjudicator includes situations where the body corporate no longer has any capacity to bring itself back into compliance with the legislation. That's a slightly different turn on what we've been discussing. And it's an interesting one, that one. So the key bit that I pick up on in that particular extract no longer has any capacity to bring itself back. So this is not about any one particular person. This is the body corporate cannot, literally cannot get itself together, cannot do what it needs to do, cannot be compliant with its statutory obligations anymore. So the body corporate has a series of obligations, and the adjudicator here is saying, well, dysfunction means, in part, body corporate simply just can't do it anymore, doesn't have any capacity to do it. And that too is the case reference for you to have a look at. So we're developing a bit of a picture. That's what dysfunction tends to sort of mean. Now let's look at it from a very, very practical example. Good old current affair. Biggest thing that I take out of that very brief clip is just the distress that those people are in. That it shouldn't be like that. Yes, being in the body corporate can be tricky. Yes, things get challenging. It shouldn't be like that, though. It shouldn't cause you to think that your only option is to go on national TV and talk about the distress that you are experiencing. You look at that property as they were doing the aerial shot. That's prime real estate. An incredible location, incredible property. But the question I'd put to people, would anybody ever want to buy a lot in that scheme? I can't see how anybody ever would after having watched that entire story. I can't stress enough to people watching this that this is the situation you always want to avoid. It's the most extreme example of dysfunction, but it's absolutely what you want to avoid. And I've spoken to so many people who are in this or a similar situation. It's just terrible. It's terrible for everyone involved. So let's keep going then. Continuing on dysfunction, here is a bit of a list of some of the red flags which might tell you that your body corporate, your scheme, is dysfunction. Now, I stress this is not an exhaustive list by any means, and it is also not a case that you tick every box and it's like, yes, we're dysfunctional, we need an administrator. It's not quite like that. These are all signs that things are going not according to plan at your body corporate. The first one, no functioning committee. And just want to be careful about that particular phrase. There is having no committee at all, which is a pretty self-evident state of affairs. But then there's the idea that there is a committee, but it's not functioning. It's not doing its job. The job of a committee, because I know some people will be watching this and going, well, what is the job of a committee? The job of the committee is to make decisions and execute them. That's what a committee does. It really doesn't do much else other than that. So a no functioning committee, therefore, is a committee that doesn't make decisions or won't or can't carry out its responsibilities. No annual general meetings. I'll share an anecdote here that I'm fond of sharing. Apologies to people if you've heard me tell this story before. I was delivering a seminar once. I won't disclose the name of the location for fear of upsetting residents of that particular location. But delivered the seminar, and then, as often happens, people come up afterwards, have a chat, ask questions, and this lovely woman comes up to me and she says, oh, Chris, how often should we hold an annual general meeting? And I had to stop and had to really think about this. I thought it was a trick question. It wasn't a trick question. It turns out that their scheme, their body corporate, was, I think, 4 lots, very, very casual. They were meeting every 2 years because nothing happened in the 2-year period. Everything was quote unquote fine. So every 2 years they'd get together and decide a few things and keep going. An AGM is the #1 forum in which critical body corporate strata decisions are made. So if an AGM is not being held, and I want to make a distinction here between an AGM not being held at all and an AGM being a bit late. They're 2 very different things. This is no AGM being held at all. Next one, no budget struck and no levies collected. A body corporate needs money to survive. That's it. It's that simple. Without money, a body corporate can't exist, can't carry out its functions. In order to have money, there must be a budget so that the levies can be determined, and then they must be collected after that. So if no budgets are struck and no levies are determined and no levies are being collected, that is usually a reasonable sign that your body corporate is in a spot of bother. No insurance is again a fairly self-evident one. I suppose the thing about insurance is that in Queensland in particular, insurance is a very challenging issue, particularly in the north of the state. You might have a situation where in all other respects, the body corporate is going really well, everything is being done, but it's through no fault of the body corporate that they can't actually get insurance. You know, it's quite commonplace to hear that some bodies corporate will ask up to 20 different insurers and they all say no, simply because of location. Even so, no insurance or perhaps under insurance can be a sign that the body corporate might be dysfunctional. Work not being carried out, certainly under Queensland legislation, the body corporate has an absolute responsibility to maintain common property. So if common property is not being maintained for whatever reason, then that is typically, not always, but typically a sign that the body corporate is dysfunctional. Misappropriation of funds, I think that's fairly self-evident to people here. I'm talking about misappropriation. It could be by a committee member, or it could be by, say, a strata manager who has access to the funds. I've got to stress to people that rarely happens. There are so few instances of either of those things happening. It has happened, it can happen. If it does happen, it's a criminal issue, obviously, potentially, but it's usually a sign that the scheme is dysfunctional. And then finally, the scheme's never been functional to begin with. And that is usually something that you find in a relatively new building, where in the frenzy of the building and development and everything else, the functions of actually holding an annual general meeting or having a committee or doing the business of the body corporate have just been not dealt with. Or you might have another common place where you find this one would be in very small buildings, like a duplex, where for many, many, many years, it's been assumed that either it's not a body corporate or they just do things casually by agreement. And while that has worked up to a point, invariably there will come a point where it won't work anymore. Someone moves on, someone else comes in, there's a big problem. So that's a set of indicators about what a dysfunctional body corporate might be. It might be simply one of those is enough to make your body corporate dysfunctional. It might be all of them, or it might be a few. There's no kind of set formula for that. All right, let's look at the flip side then. So if we know what dysfunction might be, then we need to spend a moment thinking about what dysfunction is not. And this is crucial because, as I say, so many times people will come to me and suggest that their body corporate needs significant intervention and assistance. Actually, they probably don't. There are other solutions, which I'll touch upon some of those in a bit. But these are some, again, not exhaustive, but these are some examples of what dysfunction is not. Number one, disagreeing with an outcome. People disagree with outcomes all the time in Strata. It's a way of life. Simply disagreeing with a decision reached by an annual general meeting or a committee is not grounds of itself to consider your body corporate dysfunctional. Sometimes you just have to accept the fact that you will not get what you want in a Strata scheme. That's reality, unfortunately. Personality conflicts. I think there's actually an adjudicator's order which says there's always going to be personality conflicts in Strata. I can't remember which one it is or if those are the exact words, but in any event, the fact that people do not see eye to eye, do not like each other in a body corporate, so be it. That's not great from a personal perspective, but it doesn't mean your body corporate is dysfunctional because of that. This one, I think, will surprise a lot of people. Disputes, even if there are a lot of disputes. We go back to that current affairs story a few slides ago, and I said that was and the voiceover said that's the third most disputed building in Queensland. The most disputed building in Queensland, to my knowledge, does not have an administrator appointed, has never had an administrator appointed, and I don't even know if they've ever sought to have an administrator appointed. The fact of the matter is that disputes in strata are a way of life. Not in every strata scheme, not all the time, but they are a way of life, because when you think about it, the people who comprise a body corporate or a strata scheme or an owner's corporation are brought together only through one common aspect, the fact that they all own together. Typically, they have nothing else in common. It's like a family, dare I say it. You don't have any choice. You are part of it. And so there will be disputes. Things will go wrong. You will not agree with your neighbour. You will not agree with the owner downstairs and what they're doing or what they plan on doing. Even if that happens a lot, that doesn't necessarily mean that your scheme is dysfunctional. And there's no set limit either. It's not as though you have to reach X number of disputes in a certain period of time. That's it. It's not like that at all. It's a case-by-case thing. Let's keep going. Single issue problem. Some people will argue we've got this huge issue relating to finances. That makes us dysfunctional. Well, yes and no. Typically under strata legislation, there are always solutions to specific issues. So a single issue problem usually is not an indicator of dysfunction. Removing committee members, even if that process of sacking a committee, appointing a committee, sacking committee, appointing committee, even that happens a lot, like an almost constant cycle. And there are some buildings where that happens. Even that doesn't necessarily mean dysfunction, because again, that's a way of life. And if you think about the analogy of politics, politicians are removed, appointed all the time. That doesn't mean government's dysfunctional. In fact, the counter argument is it's actually incredibly functional. It's democracy at work. And then last but not least, revenge. Revenge is never grounds for dysfunction, to get at somebody. And in fact, it's really inappropriate to think about pushing parties to the time, effort and expense of a proceeding about dysfunctionality if it is merely an opportunity to get back at someone. That does happen, unfortunately. Not all the time, but it does. All right, so we've talked about what dysfunction is and is not, and established a bit of context. Let's talk then about administrator appointments. It's the most serious intervention possible in strata. So it really is. You can have nothing more intensive than having an administrator appointed. If you want to think of it as being like having a liquidator or a receiver appointed, that might be a useful way of thinking of it. I stress to you, it is not identical. And there are some key differences about it. I won't go into those, but if for those people who are used to thinking from a corporate mindset, thinking of receiver or liquidator is a good start point for thinking about a strata administrator. So the administrator becomes the body corporate. And what that means is that owners lose their voting rights. You no longer have the right to vote. It doesn't matter if you're financial or not. The administrator becomes the body corporate. In effect, all power is vested in one person. And that's why it's the most serious intervention possible, because it takes away all of those rights and puts it into one person. And so what happens if an administrator is appointed? Well, there's not necessarily any annual general meetings. There's not necessarily committee meetings or committees. And there also aren't necessarily the options for owners to put motions. It's all up to the administrator. So you could technically have a situation where the administrator commits the body corporate to a significant contract or financial obligation. There's no obligation on an administrator to check with the owners about that. They can just do it. Subject to the terms of their appointment. So I hope you're starting to see now why an administrator appointment is so serious and not necessarily what you're after in a given situation. Let's keep going. Administrator appointments happen on application by party, and this is one key difference from that corporate context. So in a corporate situation, you might have a regulator that can come in over the top of a corporate entity and have somebody appointed to take over. That's not how strata administration works in Queensland. I think it's the same maybe in some other states too. It's actually up to an owner to initiate the process, to make the application, to foot the expense of that application, and to get it going. So they have to apply. In doing so, they must nominate a proposed administrator for the purpose. So they actually have to go out and find somebody who will agree to be appointed as the administrator. Typically in Queensland, I'd guess maybe 3/4 of all administrator appointments are strata managers. And there's a very good reason for that, because they've got that practical, hands-on operational experience, which is required to get the body corporate back on track. Not always, though. Sometimes it will be a solicitor, and that's usually for really difficult, complex administration matters. I have been an administrator as well. And then you might occasionally have perhaps an accountant or an auditor who would be proposed as an administrator. There's no set qualifications. It's just got to be somebody who can satisfy that they can do the job. When that administrator is nominated, they have to consent to the nomination, and they also have to give their fee that they charge. And I've got to tell you, administrators will charge for the privilege of being an administrator. By definition, it's an incredibly complex, difficult role. Therefore, the fee is reflective of doing that. That's an unavoidable reality of the situation. Importantly, administrator appointments are never a fait accompli. In some cases they are, particularly in those situations where the scheme's never been functional to begin with. But you can have situations where one owner applies to have an administrator appointed, but other owners disagree, and very, very strongly disagree at that. So then the adjudicator will have to make a call about whether or not it is warranted under the circumstances. In a contested administrator appointment, all owners will be asked to have their say on that appointment. So someone can contest whether the administrator is warranted. They can also contest whether the proposed person is the right person to do the job. Now, I guess this is the key point here. The adjudicator must be satisfied the action is warranted, and I'm speaking here on behalf of adjudicators to a certain extent, but they start from the position it isn't warranted. So basically, you have to persuade the adjudicator to change their mind that somebody has to be appointed to come in over the top. A little bit more, sorry, there is more. An administrator will be appointed for a defined period with certain tasks. The typical appointment is about 3 months. And in that 3 months, they're meant to hold an annual general meeting. At the annual general meeting, they strike levies and get a committee appointed. Sometimes it will be longer. Appointments of 12 months or more are not typical, I will say. It's not typical for that to happen. And the reason why is because the administrator is meant to get in there, get things on track, and then hand it back to all the owners to take care of after that. Remember, the costs for the administrator come out of body corporate funds. So, and they are often very considerable costs, as I said. So everyone ends up paying for it in the end. That will come out of levies. For those of you who want to sort of read a bit more, that link there is to the Commissioner's Office practice direction on the appointment of an administrator. It goes into some really good detail about what's involved. All right. I want to talk briefly about risks, and I've already alluded to some of these, but what are the risks of an administrator appointment? The time it takes, you're looking at 12 months for an adjudicator's order in a lot of cases. That's a long time to wait for an outcome to get things on track. The cost, as I've already alluded to, can be really significant. Then there's that impact on property values. I think that's the biggest thing, the biggest risk of all in an administrator appointment. You think about it this way. If I am a prospective purchaser and I'm doing my due diligence and I've got a conveyancer on board and they're checking adjudicators' orders and minutes or lack thereof, and they see that either an administrator is appointed or has recently been appointed or is in the process of being appointed, I'm hardly likely to buy in that scheme. It's a huge turnoff, or at the very least, my asking price will go down very quickly. One of the things I found over the years, once one administrator has been appointed, it often leads to another, and then another, and then another, because once you start, It is often very difficult. It's very difficult for the administrator to get everything done in the time frame. But even then, you've got to remember they still have to hand back to all of the owners, and that's another challenging prospect as well. So then, another Simpsons reference for everybody here. Administrator appointments are the exception, and that's how they should be regarded. I don't have the exact numbers, but I think the general rule of thumb is maybe less than 10% of all administrator applications are made. It might even be far less than that. Exceptional, keep that in mind. So then, what you want is you want to avoid it. You want to avoid it at all costs for all the reasons I've outlined. So I'm just going to go into why and how. What are the alternatives then? So if you've got some or many of those factors that I described before, what are the alternatives? First up, you hit pause. You've got to actually stop at some point. You can get so wrapped up in the situation of strata disputes, you've got to hit pause. Take a deep breath. Where are we at? Where do we need to go? What is the status quo? You go back to that current affairs story and you can see how completely captured those people were in that story by what had gone on. Sometimes hitting pause, you can get somebody to help you hit pause, bring somebody in to help you hit pause. Also, another perspective, that other perspective might be a lawyer. It might be, again, someone like myself who's a consultant in these matters. It might be a strata manager who's willing to offer some perspective. That's reasonably common, that sort of thing. Or it just might be somebody with a bit of business nous who says, look, I think you're in a bit of a tricky spot here. You might need to think about this and this and this. The bottom line is you need somebody, I think, to help you just look at this situation differently. I think it's really important to name the issues. It's so easy when you're wrapped up in the strata dispute to just think to yourself, everything's wrong. It's completely wrong. Everything's bad. Okay, what is it that's actually bad? Let's put names to that. Let's put some kind of descriptor of, is it financial? Is it insurance? Is it governance? Is it decision-making? Is it committee? Is it elections? Is it improvements? Is it maintenance? We've got to name the issues. Once you start to name the issues, it becomes less demanding to deal with. Keep going. I'm a big fan of this, what I call a structured and facilitated discussion. And so this is the, in any strata dispute, I always think that your best bet is talking about it, discussing the issue, trying to reach some kind of shared ground. That's great. Not so great when you do that and you don't have a structure around it, or you don't have an idea of what you're hoping to achieve. You don't have objectives in mind, or you don't even have an agenda. Structured and facilitated discussions are about putting some frameworks around your discussions with others in the strata scheme or one other in the strata scheme. Perhaps having a third party. I do a lot of that work with clients. Sitting in, I don't have any stake in what goes on, but I can offer people that framework and keep them on track for the discussions to ensue. I think that's an important one to think about. Then there's mediation, which is a kind of a more formal version of that discussion I just spoke about. Mediation tends to follow a pretty standard process regardless of state or territory. It's step by step by step, taking you through what's happened and where you want to be. A lot of people think mediation is a bit of a waste of time, that it just prevents the ultimate outcome that you want from happening sooner. To which I'd say to you, well, let's think of this in purely financial terms, if nothing else. You go back to that current affairs story, $250,000 versus far, 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 far less to engage a trained mediator to hold a mediation session and hopefully reach an agreement that prevents that incredible expense being needed. Then we talk about engagement and communication, and it goes back to the first point, actually talking to people, engaging people. If you are starting to get a bit concerned about what's going on in your strata scheme because some of that checklist before registered and resonated with you, chances are some of your fellow owners are starting to think that way too. Or the flip side of that, they're not engaged because maybe they live interstate or they've got a lot going on. Start engaging, start getting on the front foot with them, start talking to people about what's going on. I won't labour this point too much about lobbying, other than to say by lobbying, I mean the idea of a concerted campaign to persuade people to do what you'd like them to do, or in some cases to not do what you don't want them to do. I'm a big believer, and I've said it many times, strata and politics are identical. It's all numbers based. If you don't have the numbers, you don't get what you want. Sorry, but it can be that simple. So lobbying, when it comes to this sort of situation, if you're finding things going wrong at your strata scheme, there's an opportunity to start going out there with consistent messaging and consistent narratives to start getting people on side for the action that you want to see happening. Absolutely, you need to think about legal proceedings. Often an adjudicator's reasons for decisions, you'll see them say, well, I'm not going to appoint an administrator because there are legislated pathways to resolve disputes. You've got to use them. Yes, you might not want to use them. Yes, you might think that they're cumbersome, but if they're there, you have to use them. So with all of that in mind, here are my best practice, my top 5 tips. So we've led through all of those things. I've provided what I think are the good alternatives to administration, noting that administration, again, is, thanks, Lisa, exceptional. What are your top 5 tips? Number 1, I've said it before, I'm going to say it again, and no doubt I'll say it again. It's no fun being involved in administration, so avoid it at all costs where you can. Number 2, get in early, really early as possible. In that current affairs story I showed you earlier, those parties, those owners didn't wake up one day and go, right, we're dysfunctional today. That did not happen. That happened over a period of years. At some point, somebody there, I'm certain, knew that something wasn't right, felt that something wasn't right, considered that the circumstances at their body corporate wasn't right. Listen to that voice. Chances are that's your opportunity to get in, and prevention always better than cure. Number 3, there is never any substitute for qualified advice in this kind of scenario. So as I always say, if you have a water ingress issue, you get a plumber or an engineer. If you want legal advice, you speak to a lawyer, preferably one with strata expertise. If you want assistance in dispute resolution, someone like me. Bottom line is, don't rely upon a bush lawyer when it comes to strata issues. It's one of the biggest mistakes I see people, and particularly here when we're talking about really serious, extreme problems, always seek qualified advice. Number 4, get that clarity and specificity. What is it you're actually concerned about that is going on at your strata scheme? Get specificity, get clarity around it. Start putting names to problems. I can guarantee you it will start to make things appear far easier for you. And then number 5, and then this one's a bit inspired by Fight Club, engage with all the alternatives that I listed earlier, and I listed a whole lot of them. And if you still think that you're stuck, return to point 1, avoid at all costs. It's a bit like Fight Club, second rule, refer to first rule. I'm very, very happy to have questions. Oh, before I forget, that's me with a bit of a bigger beard in that picture. That's me with my strata approved greyhound, Ernest. Ernest looking very happy because he's outside in that one. I live in the strata scheme, and Ernest is definitely a strata approved dog. I'll just put all those contact details up there. But yeah, very happy to sort of talk with people if we've got time for questions.
That was great. Thank you for finishing the session on the top 5 tips. I think it's really great to have those positive steps and some bit of guidance at the end of it. The thing that surprised me probably when you were speaking, the main point was that it's usually a 3-month appointment. That was the thing that really stood out for me as a real surprise. I would have assumed it was a much longer period of time than that.
It does happen longer, Nikki. Like, for example, I was appointed for a longer period in a particular case, and it does happen. But that 3-month window, an adjudicator takes the view usually that in 3 months, an administrator can send out the notices, get a meeting happening, And then we come back to what I said earlier. At that meeting, that's where the big decisions of a strata scheme are always made. So if you hold the meeting, well, that's the mechanism. The problem will arise if they hold that meeting and either they just can't get people to attend or engage with it at that point. That might be where it gets a bit more complicated. But yeah, three, maybe 6 months if it's really kind of tricky. But 3 months is typically what's required. It's that handing back that I think sometimes people forget, Nikki. So yes, the administrator gets appointed, but they hand it back. That's how it's meant to go.
What options are there for minority owners in a dysfunctional scheme with a long term? Even if the administrator is appointed, they'll only rule for a period of time. And so once they leave, everything will just go back to the way it was previously.
Yeah, no, right. And look, really sympathetic to that kind of scenario. That's tough work. You're quite right. An adjudicator will not make an enduring or permanent appointment. That's just not how it goes. It can happen that an adjudicator can renew an administrator's appointment. That has happened, but again, extraordinarily exceptional circumstances. What I think you're really talking about here is this idea of it'll go back to the way it was. You've hit the nail on the head. What I think you need to be doing is addressing how to stop it going back to the way it was. So if your concern is, yes, we'll have an administrator, and then once they finish, it'll go back. You've got to spend that time making sure it doesn't go back to the way it was. And you might be saying to me, but I'm just an owner, what can I do there? Well, I appreciate that, have a lot of sympathy for that. There are actually things you can do to engage with other people and get yourself equipped to put things in a particular situation. If you're saying to me, we don't have the numbers now, and that's why these things keep happening, then one of the obvious responses is, well, how do you change that scenario? There are ways to do it, for sure.
If it's a strata manager that's been appointed and then their 3 month period is up, do they usually continue on with the strata management of the building after that period of time?
Yeah, and I should have said too, they do, not always, but they do usually. I should have also said that the administrator, if they're appointed, there's usually also a strata manager appointed as well. So it's actually a dual kind of approach, because it's a bit tricky, I suppose, but think about it this way. The administrator is in effect the committee and the body corporate. So you still have a scenario in which a strata manager does all of the strata manager's contracted responsibilities. They have to take instruction from somewhere. They have to engage with somebody about what to do. That's the administrator. So it's still that model. Yeah.
What of mandating in legislation to have annual returns lodged and non-lodgements followed up?
Not a bad idea for whoever lodged that one. I know that it's been talked about before. I've heard that discussion before. I think, if memory serves me, in South Africa, I think I once had a discussion with the relevant body in South Africa. That's what they did there. They mandate the lodgement of annual returns, and there's a fee that goes with that, and part of that fee is then devoted to the work of that body in South Africa to provide information and education. You have a similar sort of scenario for things like incorporated associations, or used to anyway, and a few other kinds of corporate entities. There's a lot to be said for that. I think that's where New South Wales is going, or has been going. I'm not 100% sure, but I believe that's the case. I think there's some benefit in that. Yeah, there are a lot of practical problems with it, for sure. I think that might be, though, a good step to try and address some of these issues. Yep.
How do we get to talk to the body corporate if not all owners want it, especially the committee who think they're not doing anything wrong? So I think they're saying to get you to come along and talk, Chris, and who pays in that situation if it's an owner that wants to instigate you coming along to talk, or somebody like you, and the committee doesn't agree to it. How does that all work?
Look, you're absolutely right. Whoever asked that question, you always should be using other people's money if you can. That's one of the sort of the mantras of life. But in this case, well, if there's no committee or they won't agree to it, yes, you're going to have to pay. And you have to think of it this way: to protect my investment and the value of that investment, is it worth my time and money to do that? that's always a question each individual has to answer for themselves. Yeah.
Okay.
That's a hard question. Yeah.
It is. Do compulsory strata management charges have to be disclosed not just by means of hourly rate, by also a total estimated figure, or does that come in when they actually bid at the beginning and disclose the costs at the beginning?
That's right, Nikki. Yeah, it's not like there is a requirement for ongoing reporting. The administrator, if appointed, quotes the cost that they would charge if they're appointed as part of their letter of consent, and that's more or less it. Yep.
Okay, and another question on cost is saying, can you give us a bit more of an idea of the costs? I mean, it would depend on the building and the amount of work that's involved.
Look, it's not cheap, and usually the usual formula is that an administrator might charge a fee per lot, and then that would be per month as well. So think about it, and yeah, it's not. I can't stress to you enough. It's not going to be cheap. Not going to be cheap. No.
Okay.
And I should have said, Nikki, in the presentation, if an administrator is appointed, one of their first tasks is to actually strike a budget so that they can pay themselves. That's actually what they do. Now, there'd be a lot of people listening and watching this going, oh, hang on, really? Yes, really. And that's precisely why the adjudicator does not want to appoint an administrator, because that's not an ideal scenario where the decision maker is paying themselves.
Maybe a comment rather than a question. Some owners think the appointment of an administrator will solve their problems forever, and they misconceive the purpose. Owners have to manage themselves, as Chris pointed out, but I understand why they feel like that. So that's just...
Yeah, look, I 100% agree with that. It's very easy to understand the idea that the white knight will come in and solve, and it just doesn't work that way.
What provisions are in place to protect minority owners in a corrupt, dysfunctional scheme run by one or two people that own the majority of the lots? Can the legislation be reviewed or revised on that? And I guess that when you were speaking initially, and you mentioned undue oppression at the very start, I wondered whether that could sort of fall under someone with majority ownership.
Yeah, that's a very specific legal question, that undue oppression or oppression of the minority. It's a very, very specific legal question. So that would require legal advice. Imbalance of numbers is a very common thing in strata. It happens all the time. That of itself doesn't necessarily mean it's a problem. The legislation is indeed currently being reviewed. I'm not sure if this very specific issue is being reviewed, but it is being reviewed at the moment. And for people in Queensland, you absolutely should be alert to what government does announce or might have on the table. Your opportunities to comment on that and be part of that process, I think, are going to come up very soon.
You mentioned we get asked quite a bit about AGMs, and you mentioned about AGMs and how it is an annual general meeting. It should be done annually, and how late is late? I guess I was asking because you did mention there's a difference between no AGM and a late AGM.
Yep. Look, it had been the case that bodies corporate could apply to an adjudicator for permission to hold their AGM out of time, or at the very least for an adjudicator to say, look, simply because you're out of time, out of the legislated time, doesn't mean that any decisions that you reach there are invalid. Adjudicators don't necessarily do that all the time, and they now these days, and they kind of thrown it back to the body corporate to sort of suggest to them, perhaps that's part of your reasonable decision making. It always depends on circumstances, Nikki, and the best example that I could give to people is that if your AGM is not being held because there is a desire to not have one because you can't be bothered, or you don't want to have to consider any motions that are going to cost money, that absolutely will not cut the mustard. No.
Where does the application go? Is it court or QCAT?
Commissioner's office.
Okay, that's great. What can an owner do if they suspect financial misappropriation from the committee? That's quite a big question.
Yeah, look, you've got to be very careful using that phrase, misappropriation. It's a big call. So be very careful before you start saying that. But if you have taken care and it does look like that's what's happened, that's typically a police matter in the first instance. Yep.
Chris, no doubt we'll see you in the very near future on another session.
I hope so, Nikki. Thanks everyone. Thanks for taking the time to hear me waffle on. Appreciate it.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.